Question is the bill be now read the second time. The honourable member for Nelson.
Just remove some remnants from another speech. Don't know if I agree with them, so I better not read them. Thank you, Mr. President. I rise to speak on the University of Tasmania Protection of Land Bill, noting agreement with the member for Elwick that this is actually quite cruelly, ironically named bill. This bill, Mr. President, is a matter of particular interest to me and my constituents in Nelson, as it relates to the Sandy Bay campus of the University of Tasmania, which is situated in the lovely, beautiful electorate of Nelson. Specifically, the Sandy Bay campus extends across areas of the suburb of Sandy Bay and also adjacent to the suburb of Mount Nelson. I'd also put on the record here for the purposes of this debate that I am currently a resident of Mount Nelson. I rent a home in that suburb, and although I do so, it's not directly adjacent to the area that's dealt with in this bill. I am also a member of that community. Mr. President, matters relating to the Sandy Bay campus of UTAS have been an active area of interest and concern for Nelson constituents the entire time I have been their elected representative in this place. At the time I first campaigned for the seat in 2019, we were in the early stages of a very contentious community conversation about the proposal to move the entire campus into the Hobart CBD and see the Sandy Bay campus fully redeveloped. Community concern for residents of Sandy Bay and Mount Nelson only grew from that point, and at that time it was already of high concern. A great deal of energy was mobilised in the community to oppose that original proposal of a wholesale campus move. The community campaign effort resulted in public meetings and an elector poll held in conjunction with the 2022 local government elections, which delivered a damning result of 74% of voters in the elector poll being against the move of the campus to the CBD. And that was after an extensive advertising campaign from the university, putting both the Chancellor and the Vice-Chancellor at the very forefront of that extensive and expensive advertising campaign, which the people of Hobart were utterly unconvinced by. The issue of changes and potential disposal of the Sandy Bay campus has continued to be very much a live matter of discussion and concern for the residents in Nelson. Last year, when I was campaigning for re-election, we did extensive door-knocking in Sandy Bay and Mount Nelson, and the rezoning proposal in this bill was a topic raised frequently as a matter of concern, and I can say there was virtually no support for it in the community that was raised with me while we were doing that door-knocking and campaigning. Mr. President, the original election commitment which led to this legislation was made by the Liberal Party in the context of the 2024 election and was a fairly straightforward proposition to require parliamentary approval for disposal of gifted land in Sandy Bay, gifted land to the university. Then, in an abrupt pivot that was made after the bill had been tabled in Parliament, the government put forward an amendment to their own bill to include a parliamentary rezoning of parcels of land above Churchill Ave. This was, of course, very jarring, given it was inserted into the very bill which was to give effect to a promise to provide greater protection to the Sandy Bay campus land. The irony, Mr. President, the cruel irony. It was also an extraordinarily inappropriate attempt to dodge the governance and probity requirements of a regular planning system rezoning process. This is plainly an attempt to cast aside all expected elements of a good practice planning decision, including assessments of environmental, social and infrastructure impacts, community consultation processes, the provision of independent expert advice to decision makers, to name just a few, in an effort to ram through an outcome for which no robust business case exists and is highly questionable in terms of the long-term public interest, not just of Sandy Bay and Mount Nelson, not just of the Nelson electorate, not just of Hobart, but of Tasmania itself. Mr. President, these are matters I will speak on in more detail in my contribution, but before that I would like to put it to members that it is a presumptuous affront to demand this Parliament, this chamber, act as a planning authority without making any coherent case as to why this should be necessary. I ask all members here, if there was a major planning decision in your electorate which had a significant demonstrated community opposition and which had impacts that would be permanent and substantial in shaping two suburbs comprising a large part of your electorate, would you find it acceptable and appropriate to have that planning decision taken from the regular planning system with its checks and balances and brought to this Parliament abruptly like this, shoved into a piece of legislation designed to do the very opposite? Would you find it appropriate if it was done in a way that avoided any of the requirements of the planning system or even of the Housing Land Supply Act, which is our other way we rezone quickly through this place? To underpin its consideration in this place, would you find it appropriate that it was presented without a comprehensive business case, let alone any assessment of the social, economic and environmental impacts or credible community consultation demonstrated? Oh, and at the same time that the local council in that area in your electorate, in this thing we're imagining here, this hypothetical, at the same time the local council was developing a neighbourhood plan for the same area, but yet to complete that process, would you, each of you here in this place, as a member of your electorate, representing your electorate, feel that that was appropriate and something that you could support? I put it to you that it wouldn't be, and if it wouldn't be appropriate and able to be supported in your electorate, why do you think it's appropriate to be supported in my electorate? The rezoning attempt in this bill, Mr President, is a huge red flag on integrity and good governance in our state. It comes after the Rockcliffe government has developed a bad habit of bringing planning decisions to Parliament, but this time, as stated also by the member for Elwick in her contribution, this time there has not even been an attempt to put this through or be assessed under the regular planning scheme. A clear message should be sent from this chamber that this is unacceptable. To sidestep our legislated planning scheme, especially via a behind closed doors arrangement directly with our Premier, it is unacceptable, Mr President, and this chamber should be sending a message back to the government that it's time to break their habit, especially when they're taking this to a new precedent of bad governance. Mr President, to elaborate on some key points here, I'm going to start by speaking about the original commitment that sits behind this bill. After that resounding defeat of the first proposal to move the Sandy Bay campus into the CBD, there was clear community sentiment about the value placed by the community on the Sandy Bay campus of the university. And the Liberal Party then went to the 2024 election knowing that it needed to sandbag a potential loss of votes in Sandy Bay due to the UTAS campus issue. And so, to sandbag that, to stem the bleeding, the Liberal Party made an election commitment. The 2024 election promise from the Liberal Party was to insert into our University of Tasmania Act a requirement for UTAS to seek parliamentary approval for the sale or long-term leasing of gifted land, the Sandy Bay campus. Mr President, that was a good idea, much that it was done for very, very poor reasons, self-interested reasons by the Liberal Party. It was the right thing to do. It was in line with a finding and a recommendation of the UTAS inquiry that this place undertook and reported on in 2022. I think we began it in 2022 and reported in 2024. Still waiting for a response on that, of course, Mr President, that inquiry. The government apparently can't respond to our inquiry because there are still matters going on at a national level that relate to university governance. Those matters completely align with so many of the findings from our inquiry, all raising highly concerning questions about university governance across the nation, including here at UTAS. Now, while that's all still in train apparently at a national level, huge concern about university governance and how poor it is, The government can't respond to our inquiry and its recommendations, but apparently it can allow the university to make place-shaping decisions about matters to do with our capital city, even though governance questions hang over this university, as well as others in the nation. We can't respond to an inquiry while that's happening, but we can actually let the university charge ahead through special deals behind closed doors to have a permanent impact on a jewel in the Crown campus at Sandy Bay and the impact it will have on the suburbs around it. Astonishing, Mr. President. Astonishing. Mr. President, it was the right thing to do to insert into the University of Tasmania Act some sort of requirement for there to be oversight of a decision to sell campus land that had been gifted in Sandy Bay. That would put us in line with other jurisdictions who have similar sorts of requirements. There's a variety of them, but they're all similar intent to put some sort of oversight in place, because otherwise university councils or similar governance mechanisms are virtually a law unto themselves, actually. There's very little accountability for those bodies. It was appropriate too, given the context of the place-shaping decisions that would be made by UTAS Council in relation to that campus, the one of which we're seeing right here in this bill, and to which Hobart citizens have consistently demonstrated that they strongly object to. So a bill was developed to give effect to the election commitment made, and it was tabled in the House of Assembly on the 20th of June 2024. The government had also made its expectation clear that any proposal for sale or long-term leasing of land brought to Parliament under the original bill would be expected to have a full business case provided for consideration. Indeed, this was confirmed on the 7th of November 2024 by Minister Ogilvie on ABC Radio Mornings programme, where she said this, and I quote, "What I have said is I want to see the full business case of what the proposal is, and my view is that business case ought to come through Parliament. So that's our position." End of quote. Mr. President, that was the original intent stated by the government, very clear and committed to at the end of at the 2024 election, and still being put forward 7th of November 2024 by Minister Ogilvie, that the government would be expecting to pass this legislation which put a new requirement to come through Parliament, and that a full business case would be expected to accompany any such piece of proposal to come to us. Mr. President, that commitment at the election and then the subsequent work done on the bill was something that had been factored in by many voters, I think, who are residents of Sandy Bay and Mount Nelson, and they were reassured by it in the original sense. But then something happened, Mr. President. Something changed after that original intent and the work that was done to begin giving effect to it through a bill. Something happened behind closed doors, because having made the commitment to protect the Sandy Bay campus via this bill, 1 week prior to debating it in the other place, on the 28th of November 2024, the government put forward an amendment to insert the rezoning provisions which we now see in Clause 7 and Schedule 2 of the bill. What did happen, Mr. President? What did happen between times? Well, certainly after the Liberal Party had made that election commitment, and then post-election when the Liberals formed government and work began on a bill to give effect to the commitment, UTAS certainly started arcing up, no doubt, over the bill, started getting very fussed about the requirements that would be put on them and the constraints that would be put on them through that bill. And they no doubt started talking to the Liberal Party behind closed doors, the now Liberal government. They also started talking to the Labor Party, Mr. President, and that became very uncomfortable for the government, because with the UTAS talking to the Labor Party and stirring up the Labor Party about the problems of this bill, they were able to trigger, of course, some political argy-bargy. And that becomes very uncomfortable for the government when, and it's interesting, a significant public institution like UTAS to actually politically use an opposition to put pressure on a government is quite an interesting decision when you think about the integrity of an important public institution like UTAS. So the government became very uncomfortable with UTAS talking to the Labor Party, stirring them up about this bill, and then also no doubt coming under pressure and interacting with UTAS about it, also behind closed doors. And eventually a deal was come to with the government committing to circumvent normal planning laws to facilitate rezoning of the upper campus by attaching it to the bill. But I think it's actually important to state here what we now know about some of the things that went on behind closed doors at that time, Mr. President. Certainly there's been extensive RTIs done on matters relating to the interactions between UTAS and the government around this decision and how they came to actually completely pivot to insert something that was certainly against the original intent of the bill. The RTI documents that have been sought and received were both from DPAC and from DSIP and from UTAS, is my understanding. And it's interesting, I think in excess of 1,700 pages have been received through RTI on this matter. And there's a few things that come to light through the documents, even through the redactions that are rife through them. One of the things that's clear is that Ministers Ogilvie and Palmer, who were the original ministers most relevant and responsible for the bill, as intended from the election commitment, maintained a steadfast arguing in favour of the original form of the bill. They maintained that all the way through to July 2024. But then something changed on the 2nd of August 2024 when UTAS Chancellor Alison Watkins wrote to Minister Ogilvie revealing that UTAS had appealed over the heads of Ministers Ogilvie and Palmer. She'd gone above them to the Premier himself, Premier Rockliff, and that UTAS was now dealing directly with Premier Rockliff and his office on this matter. It indicated that a meeting was held between the Vice-Chancellor, convened with the Premier on the 23rd of August 2024. RTI documents provided by DSIP indicated that Minister Palmer had ceased to have any real responsibility for this bill from the 30th of September 2024 onwards. RTI documents also indicated that DSIP would continue to brief with a strong line against UTAS's criticism of the original UTAS land bill. DSIP were continuing to argue that it was ill-founded, these criticisms, at least until the 30th of September 2024, which is very interesting. Clearly they were well out of the loop of the behind closed doors conversations between the Premier and UTAS, and perhaps DPAC folk and UTAS on behalf of the Premier. The exact process then leading to the amendments that inserted the rezoning is somewhat obscure. It's actually quite murky still, even given RTI documents received. But the Premier and his office were certainly closely involved. Drafting responsibility for the amendments seems to have not been sat with DSIP, but to have transferred to DPAC. In its RTI response, DPAC, though, has failed to even identify that any documents or correspondence, it would appear, relating to drafting instructions for the amendments exist. They haven't come forward through the RTI process, which I find quite astonishing, because obviously drafting instructions on this amendment came from somewhere in the government. Someone asked OPC to draft the amendment that the government put onto its own bill. Who was it? And if those drafting instructions, and even if they were redacted under RTI, we should still see that there was an email or a piece of correspondence or something that related to it, but no, that didn't emerge through the RTI process. That tells us either something really weird was going on in terms of advising and instructing OPC, or DPAC have utterly failed to comply with the RTI Act in relation to these RTI requests. Both of those eventualities, both of those options are highly concerning and reflect on DPAC, I think, unfortunately. However, documents largely obtained under RTI from UTAS show that DPAC and UTAS were working closely and intensively on the amendments in October and November of 2024. This work between UTAS and DPAC involved a number of people who were senior in both those organisations, and quite likely some of whom sat before us yesterday in briefings and said to us, to our faces there, that they didn't know where the amendments came from. I'm not going to reflect further on that, Mr. President, other than to say that's highly disappointing. And perhaps if better information had been released through RTI that clearly mapped out, or even if it hadn't had to be RTI'd, even if the government had been prepared to be upfront about how this process worked, how this decision-making about this rezoning amendment worked, If that was something the government could be transparent about, or UTAS could be transparent about, then we wouldn't have to wonder who'd done something murky here maybe, Mr President. So the draft amendments went to Cabinet on the 18th of November 2024, we find out from RTIs, and the bill was probably expected to be done and dusted quite quickly at the end of 2024 once it went through the lower house. It would have been expected probably to come to us at that same time and go through here. Interestingly, Mr President, that's not what happened, of course. And when things get drawn out over time, there's plenty more time then to start digging into what has happened, particularly some of the murky areas around decision-making and around deals done behind closed doors during that decision-making process. So we end up with a bill that now has a rezoning clause in it, even though it's called a protection of land bill. We're going to ditch some land while we're under the protection of land bill. And that's come to this parliament, and it's effectively has put us in the position yet again of being a planning authority. In that, it hasn't been tested through a normal process. It hasn't gone to the local council that it should have gone to, the City of Hobart. It hasn't gone through any Tasmanian Planning Commission process. It's come straight to us. And as I think members probably received an email from Brian Risby, previous, I think, Director of the Planning Unit or Planning Division in the government, now retired and no longer working there, wrote to us by email. And some of the things he said is this in relation to this positioning of the Parliament as a planning authority on this matter. He said, and I quote, "The point here, though, is not whether the land in question should be rezoned and sold off, it's the process for determining that. While Parliament has acted directly in the planning system a few times in recent years, at least those have all been informed by the processes of relevant local councils or the Planning Commission. In that sense, honourable members were acting more like elected councillors with access to carefully considered professional assessment before they voted. Even the more contentious housing land supply orders, such as for Huntingfield, were fully consulted on, assessed and reported on by planning professionals, but not so in this case." So Mr Brian Risby there, Mr President, is indicating why he, as what we would all regard as an expert in this field, thinks that this is an inappropriate use of Parliament acting as a planning authority. Section 7 of the bill is not supported by any planning information nor expert assessment made available to us as the decision makers here. It doesn't even provide us what's required under a housing land supply order, which, just to remind ourselves, includes being able to demonstrate that the land is suitable and well serviced, that the proposed zoning is consistent with state policies and regional land use strategies, that the proposed zoning is consistent with Schedule 1 objectives of the Land Use Planning Act, which requires that economic, environmental and social effects have been considered, that there will be no significant land use conflict, and that public infrastructure is protected and the provision of utilities are protected. That would be required under the housing land supply orders, and it's not required here in this instance, even though this is an incredibly major piece of rezoning and planning decision-making that we are expected to give effect to in this place. That some members, astonishingly, are prepared to do without any of that in place for us to consider. I also note, in correspondence to us from the National Tertiary Education Union, the NTEU, they've also raised concerns around this positioning of our chamber as a planning authority. I'm going to read some things from their letter that they sent us because I'd like it to be on the record from some of these key stakeholders how concerned they are about these matters. NTEU says, perhaps the most egregious and enduring concern the NTEU Tasmania holds about this legislation is the process by which the rezoning of the land above Churchill Avenue is being affected. Clause 7 of the bill rezones specific parcels of land from particular purpose zone 3 to inner residential by Act of Parliament. This is not a planning outcome produced by the planning system. It is the planning outcome produced by legislation without geotechnical assessment, without transport infrastructure analysis, without community consultation through the established planning scheme amendment process, and without the involvement of Hobart City Council, whose neighbourhood planning process for Sandy Bay and Mount Nelson was already underway and had engaged community members, residents and experts in good faith. The government has acknowledged that this approach is taken precisely to avoid Hobart City Council rezoning process, which it describes as lengthy. That is not a justification for bypassing the process, it is a description of the problem. The community consultation, expert assessment and public exhibition that accompany a proper planning scheme amendment exist to protect the public interest. They exist to ensure that rezonings are appropriate, evidence-based and informed by the people most affected. Circumventing them by statute does not speed up good planning, it replaces good planning with no planning. They go on to say, Mr President, the Legislative Council has a long and proper tradition of acting as a house of review, scrutinising legislation in the public interest and insisting on appropriate process. The NTEU Tasmania urges members to exercise that function here. If this rezoning is genuinely appropriate, it can be accomplished through the established planning system with proper community engagement. If it cannot withstand that scrutiny, it should not be accomplished at all. Parliament should not substitute itself for the planning system whenever the planning system is considered inconvenient. The precedent this sets, that land use can be changed by legislation without independent assessment or public process, is one with consequences well beyond this particular bill. End of quote. That's spot on, Mr President. Absolutely spot on. As I said in my opening, this is unacceptable. And all members here should see this as a precedent that should not be set. And if it's set, it risks being quite a dangerous one. It's a slippery slope to people feeling they can go straight to the Premier behind closed doors and have our planning system disregarded entirely without having even attempted it in the first place. And I know the university says they did attempt it back in 2021, but that was with the master plan that related to the whole campus move, Mr President. And what was clear to them then is that that wasn't going to fly. And then they didn't actually come back with this proposal and put it through the planning system where it should have gone, through Hobart City Council. They should have done that. That would have been the right way to do it. They knew that there would be some friction in doing that, no doubt. They knew they would have to face some of those requirements, including community consultation. And they knew full well that that wasn't going to go all their way. And with that uncertainty in front of them, they've chosen instead to do the wrong thing, to discard integrity and good process and good governance. They've chosen to be sneaky and go to the Premier behind closed doors to make a secret deal. And they've decided to use political influence to do that by operationalising the Labor Party opposition to put pressure on the government and make them feel unsafe. Absolutely astonishing behaviour from a public institution, Mr President. Astonishing behaviour. But then there's been a lot of astonishing behaviour under the leadership of this institution in recent years. But back to this bill, Mr President. I'd like to talk a little bit about the inner residential rezoning that is given effect to if this bill passes. The bill automatically rezones all the parcels that are described, the two parcels, particular parcels of the land, to inner residential zoning under the Hobart Local Provisions Schedule. Mr Brian Risby has something to say about that in his correspondence to us. He says this about it, and I quote, "The rationale for this appears to be to maximise its development potential and thereby its financial value, presumably so UTAS can fund the development of a new STEM facility on the remnant campus below Churchill Ave. A worthy cause perhaps, but this part of the bill represents a flagrant abuse of process without any apparent strategic basis." He also says this, Mr President, and I quote, "The only justification appears to be that part of the land in question adjoins an area currently zoned in a residential. Few planners would think the highest density zone makes sense on most of this challenging terrain." Mr President, this, of course, is a highly credentialed planning expert saying this to us. He also goes on to say this, Mr Brian Risby: the reality is that despite the zoning, it will be the Hobart City Council that has to assess the future subdivision and any associated issues with servicing and road layout. At the end of the day, I doubt that the intent of the inner residential zone will be deliverable on much of the area, and its blanket application will delay the development at later stages. So any perceived gains in time through this legislative rezoning will likely be counterproductive. Areas like this, with complex layers of environmental infrastructure and topographic constraints and opportunities, need a structure plan to guide the development potential, with the zoning to follow and reflect that. The Huntingfield Housing Land Supply Order included a range of zones not selected arbitrarily, but based on a master plan. Interestingly, a careful reading of Section 7 of the bill suggests that, in fact, the inner residential zoning may only be a holding position anyway, because subsection 8 allows any of the land to be rezoned to something else in the future, presumably following a proper strategic planning process initiated by the Council and approved by the Commission. End of quote. So that would be the regular planning process that may have to come into play down the track, Madam Deputy President. It's astonishing to me, as Mr Risby identifies there, to just blanket rezone these two areas is absolutely unheard of in a responsible planning sense. That is not what we would expect to happen under a normal process. That is not what a planning expert would do here if they were progressing it. And in fact, it could be false economy. This was done to get things done quickly, to not have to go through troublesome, friction-filled processes at the local council level or the planning commission level. And what's been pointed out here by Mr Risby is the fact that it might be false economy in terms of time. It's already taken 2 years probably instead of the few months that was hoped. And here we are down the track, as has been pointed out in that section I just quoted, down the track probably having to redo the work through the normal system at a later date. So this is false economy. It's poor practice. Often when you rush things and try to sneak around them, what you end up with is something that's a bugger up, excuse my unparliamentary language, Madam Deputy President, but has to be fixed up later. We don't know whether these two parcels of land should be zoned in a residential. We don't know that, because we haven't been given the right information to make the assessment as the decision makers. Should there be a more nuanced approach to zoning on these two parcels of land? We don't know. Probably, an expert has said to us that's probably what should happen. But again, we haven't been given the right information, any information, upon which to make that determination. It comes back to the fact that what's being done here today is an absolute abhorrence. It's poor practice, it shouldn't be done this way, and it sets a precedent. I was interested too, because in Mr Brian Risby's correspondence to us, he also picks up on the fact that there were already processes underway relating to this general area, and that this process here with this bill through this place really makes a mockery of that to some extent. He says this in his letter, and I quote, "What makes this even more unjustified is that the Hobart City Council is midstream on exactly the strategic work required to determine the right mix of zones for the broader surrounding area, and the arbitrary exclusion of such a large area of land not only means they will need to start again, but they will have to do so with the zoning predetermined for this large strategically positioned parcel. Moreover, this presumptive rezoning will have implications for the land around it, as the council will need to limit the extent of other high-density residential land because the overall density for the area will be distorted by the legislation." End of quote. That's astonishing, Madam Deputy President. So not only are we putting the cart well before the horse in terms of not waiting for the Hobart City Council's strategic planning work to be done, we're actually shaping inappropriately what that work can then deliver, because we've dumped in this inner residential parcels right into the middle of it. And that will limit opportunities for potential other development proposals nearby. That's not very fair, it's not appropriate, and it doesn't make for good city planning. Hobart City Council passed a motion on the 15th of December 2025, and it said this: the Council notes, 1, there is no business case supporting the extraordinary use of Parliament by the Tasmanian Government to attempt to rezone 2 sections of land at the University of Tasmania's Sandy Bay campus through the passing of the University of Tasmania Protection of Land Bill 2025. 2, Hobart City Council officers recommended the usual statutory process for rezoning land should be followed rather than rezoning through legislative processes. 3, UTAS has committed to rejuvenating and rebuilding a STEM centre on the campus based around the existing STEM facilities that already exist on that campus. 4, the land proposed for rezoning is fire-prone, steep, rocky, has limited road access and is unsuitable for the high-density development possible if it is rezoned as inner residential. 5, the Sandy Bay Mount Nelson Neighbourhood Plan is currently being formulated by Council. The draft plan recommended staged and sensitive urban renewal if this land was to be developed, and UTAS undertook to use this neighbourhood plan to inform its campus plans. And the Council, 6, completes the Mount Nelson Sandy Bay Neighbourhood Plan as soon as possible. As soon as practical. 7, submits the completed Mount Nelson Sandy Bay Neighbourhood Plan to Legislative Council as a matter of urgency so that it can be considered as Hobart City Council's contribution to the debate of the University of Tasmania Protection of Land Bill 2025. 8, write to Legislative Council requesting that they defer final decision on the University of Tasmania Protection of Land Bill 2025 until they receive the submitted Mount Nelson Sandy Bay Neighbourhood Plan for consideration. End of the motion. Madam Deputy President, that's a really clear piece of communication from the key local government area affected here to this place. We all received it by correspondence. The Mount Nelson Sandy Bay Neighbourhood Plan has not been completed and provided to us to inform this decision. We don't have it. We have a discussion paper that was put out for consultation, and we have an engagement report saying what was heard in relation to that discussion paper. I note the government likes to point to the discussion paper as if it somehow proves that the Hobart City Council supports the sort of development they're intending in this area. It doesn't. It's a discussion paper that's put out to the community to respond to. The engagement report, which the government takes great trouble not to mention, the engagement report makes it very clear that there is a fairly comprehensive opposition to the sort of development, the wholesale rezoning like this of